Thank you. For those of you that don't know me, I am Frank Podobnik. I am the Division Administrator of the Special Ed Division at OPI. And I just am here to welcome you and say thank you to you for coming to attend the training today. I've had the opportunity to hear Art speak at the Tri-State Law Conference previously, and you'll enjoy him very much. He's very informative and will keep us entertained. He just delivers so much information that you won't believe how quickly the day will go. And so I just wanted to say thank you too for all that you do for our kids in Montana and for making sure that all our kids are getting all of their needs met, and that you're here to learn more about how to do that in a way that keeps you out of trouble with the rules and all of that stuff. So thank you very much. And now Mary Gallagher is going to introduce Art for us.
This is a motor skills test, I think. We'll see if I can pass it. Good morning, everyone. My name is Mary Gallagher, and I do the Dispute Resolution and Early Assistance Program portion of special education for the Office of Public Instruction. And our two helpers today that hold down the fort with the due process hearings and state complaints are Linda Brandon Jose, that you probably all have talked to over the course of time, and also Bev Marlowe, who is in the other room signing people up. So we were very pleased to see that there were so many folks interested in this, and we initially, I just wanted to let you know how this came about, because the OPI had done a survey last year that said, what are the special education needs that that are out there in terms of training that the OPI can help you with? And special ed law was definitely one of those ones that was at the top of the list. So the training today will go from 8:30 to 4:30, and we'll have a break at 10:15. We'll also have one at about 3:15. Art's in charge, so I don't know exactly. There'll be some leeway there, but I think he'll probably also try and get you out of here a few minutes before noon so you can beat the lunch crowd. And as you probably already know, CEU credits and CLE credits are available for this training, so those will be available to pick up the forms this afternoon from Bev. Also, I would like to acknowledge the OPI hearing officers and mediators that do so much work for our office and come to trainings many times, to their chagrin, not getting to do any due process hearings or mediations because there aren't as many as some other states. But if the hearing officers would stand, we can give them a round of applause for all their work. They're over here and right there. So. Thanks. Okay. Without delay, it's my pleasure to introduce today the speaker. I have had the pleasure of hearing him speak at seminars, at regional special ed law conferences over the past several years in Portland and Omaha, and I'm not sure where else, but he is frequently tapped to do specialized presentations to state and local special educators and administrators, as well as to parent organizations. And he has practiced in the field of special education law for many, many years. He's also been a teacher, which is helpful to bring that perspective when you are training a crew like this. He's been a consultant to our the regional Northeast Regional Resource Center. We use the Northwest one, but he is from Vermont, and so he has taught or consulted with the Northeast Regional Resource Center, and he served in the Vermont Department of Education as a Special Assistant Attorney General, doing education law for the state of Vermont. He practices, or his practice runs the gamut of practical experience from being a surrogate parent to national trainings and technical assistance with everything in between. We are pleased today to be able to present, and I ask you to welcome our National Education Law Speaker, Art Cernosia.
So who woke up this morning saying, I am so excited I get to spend the day with a special education law attorney? Really? Things are that bad back in your... Well, I really am pleased to be here, and I want to thank the Montana Office of Public Instruction, Frank, and in particular Mary and Linda, who I was working with in terms of all the logistics. Hearing officers, we get to meet again tomorrow behind closed doors. But the department wanted to open it up to the parent advocacy community and the school community today, so everybody is on the same page. Because I firmly believe that this law is really built on relationships. And relationships oftentimes is based on what? Respectful discussion and communication. So I know when I go into a state, I always like to have the parent advocacy community and the school community together so that we could hear the same information and have discussions and be on the same information level. How many of you have seen me present in regional or federal? Okay, seems like the people along the wall there. For those of you who I have not met, I have a little commercial announcement that I am required to make, brought to you on behalf of the malpractice insurance industry. Welcome. I am an attorney licensed to practice law, but not in Montana. But even if I was, today is not intended to be a free legal advice seminar, but an update on special ed legal issues. I hope today will be useful and practical. We will assume that any question that you pose is based on a hypothetical student in a hypothetical school, in a hypothetical school district, in a hypothetical state that starts with an M. Therefore, before you take any real action in a real case, please consult with the necessary authorities back home. Is there a need for any questions or clarification? Thank you on behalf of the malpractice insurance industry. You know, I really need to get that like pre-recorded. I'm so tired of saying that. But on the other hand, I have had situations where people, you know, pose a little vignette, and I said, well, that doesn't sound like that's really what the law anticipates. And then I get a call at home that night from a superintendent and said, we spent good money sending our staff to your workshop, and you told them that what we did was illegal. I said, hypothetically, that's not true. But you may have left out, you know, one factor situation that you didn't think was relevant at all, but that could have turned the whole analysis. As far as my hearing officer friends go, it is not my role as a consultant to tell you how to rule. Now this is somewhat a misnomer. It says a year in review. Mary actually asked me to highlight the significant developments in the last 2 years. And you have a packet of information. Our friends out in cyberspace, Mary has said that she will make sure that that is posted on the department's website, so they will have access to this. I was already asked, I don't really think my PowerPoint adds anything that's not in here, but I will also send that to the department, so you will have access to that. Especially for my friends who are hearing officers. Since I'm being recorded, I want to say this. I happen to believe that my summaries of these cases are accurate. However, as hearing officer decision makers in particular, it's incumbent upon you to read these decisions yourselves, give it your own independent reading and application to the facts in front of you. So on with the show. And again, please don't hesitate to raise your hand with any comment or question. You could even disagree with what I say, in which case Mary will take your name down and we will chat later. The one thing I have not put in the outline, and this doesn't really focus on hearing officers as much as the special ed community generally. The U.S. Department of Education has now established an effort. It's called Results-Driven Accountability. How many of you are special ed administrators? And you know the department has a legal responsibility under its general supervision responsibilities under the IDEA to come in and to monitor you periodically, or respond to administrative complaints, or due process hearings, etc. And the feds monitor each state. And over the years, it's really been focused on compliance of procedural requirements. Well, the department is, at this point, temporarily halted all of their monitoring visits. Although they didn't call them monitoring any longer, they were going to be improvement efforts. So you may not be able to see all the font there, but bottom line, the department now is taking the opportunity to solicit public input to see how the efforts of the feds should go forward in the future, from focusing solely on procedural compliance to outcomes of students. Now, if I had to predict, I think what we're going to see is you are going to be still held responsible, and so will states, for all procedural compliance. But we're going to see added to that some emphasis on being responsible for student outcomes. What that looks like, I don't think anyone really knows yet. And that's why the U.S. Department of Education is soliciting public comments. But that potentially could change all your lives. Now, we know, and when I do training like of IEP meeting facilitators, have you ever gone into an IEP meeting that says, welcome mom and dad to this LEA, we're going to be revising your child's IEP that will provide a FAPE in the LRE, and we may be adding a BIP. Now, some of you just understood what I said. I mean, think about that. Discuss. How many of you know what I taught when I say SPPs and APRs? State performance plans and annual performance reports, where the U.S. Department of Education has established state performance plan requirements with multiple indicators that every state has to set targets over, and every indicator collect data from all the local education agencies in the state and report that data then to the feds through the annual performance report, the APR process. That is driving business in the states of special education. This is going to be kind of the replacement. So I just wanted to alert you to that. I also wanted to alert you, and you'll see this on page 1 of the outline, and again, our friends who are watching over the internet, the outline will be made available to you, but in May of this year, the U.S. Department of Education issued guidance on restraint and seclusion with 15 principles. All I wanted to point out is I've read all the Montana state statutes and the administrative code, and I know you have code provisions that address this. Not all states do, but you do, and we'll talk about that later today. These principles are in place to encourage states and local education agencies to, at times, to establish, at other times, to review their established policies to see if they need, shall we say, some additional thought and refinement. Now, the one thing, these are guidelines for hearing officers in particular. In the footnote number 1 of these guidelines that are getting a lot of attention nationally, it says, these are intended to be technical assistance guidelines. They do not establish new compliance requirements for schools, school districts, or states. So I can't find you out of compliance for not following a guideline. But I noticed in your state code, a lot of the guidelines that the feds have included in this document are already in your code, such as you don't use restraint or seclusion for discipline purposes. You use it as a last resort after other positive behavioral interventions have proven ineffective. You use it only as a last resort when what? There's an imminent threat to the child's well-being and safety. So that's all I'm going to say, because we're going to talk, all I'm going to say about these guidelines, because we're going to talk more about what Montana Code says later today. Child find. Your responsibility as a public school to identify, locate, and evaluate students who may be disabled and in need of special education. If you look under paragraph 1A on the bottom of page 2, and I note from your administrative code requirements, especially when a school district establishes or makes a referral, you are to do what? Document your consideration of general ed interventions prior to receiving that point. Actually, data was released earlier this week by the U.S. Department of Education that shows now for the 5th consecutive year we are seeing a decrease nationally in the number of children identified as special ed eligible. Now, I think it would be too simplistic to say it's because of one factor. But I think who here doesn't have some level of a general ed intervention process that is considered before a child is automatically referred for a special ed evaluation? In other words, there's a lot of children with special needs who don't need special education. Not every child who is struggling academically or behaviorally should automatically be sent forward for a special ed evaluation. Now, I was a former high school social studies teacher in Illinois. I saw 136 kids every day. I worked in a school, that was in the last century. I worked in a school where every 52 minutes we moved them in when we moved them out. I didn't know those kids individually as I should have, even though I was going to be the teacher that changed the world. I do think I made an impact. This was a long time ago. I still hear from some of my former students. This is when 94-142 came out. But I know that some kids learn differently. I'm a parent of 2 sons, and you'll probably be hearing some stories about them. They are out of college. My oldest son really struggled academically. We didn't think he would ever finish high school. And our youngest son was our academic all-star. And I like just a brief update. They have both been successes. I like to say every kid is gifted depending on how the package is wrapped. You know, but some kids, if they're struggling academically and behaviorally, they should not automatically be sent for a special ed evaluation. Now, I'm going to be talking about general ed interventions, and then I'm going to be talking about this thing called RTI. My blood pressure's rising. I'm channeling my doctor to say, it's okay, it's okay. But I want you to be aware of the first case in the outline. It's called AP versus Woodstock. And again, how many attorneys do we have in the room? We are outnumbered. We should all be sitting together here. Yeah. But for the non-attorneys in the room, you will see that this case is from the U.S. Court of Appeals from the 2nd Circuit. Montana is in the 9th. So when you see 9th Circuit, you need to pay special attention because those cases are of very important significance for Montana. In the event the 9th Circuit has not spoken, then you look to other cases in other jurisdictions for persuasive authority. In this case, by the way, how many of you have heard of the disability category called a non-verbal learning disability? Well, did you hear that? A nonverbal learning disability. In some parts of the country, it is hot, 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 hot. In other parts of the country, they go, say what? In this case, here was a child who was struggling academically, but socially in particular. He was sent by his classroom teacher to the general ed intervention team. I think they called it a child study team. I've seen it's called a student support team, a student help team. I'm going to call it a general ed intervention team. The parent was informed of that. A set of interventions were developed and implemented, and it was relatively late in the school year that there wasn't a whole lot of progress, but there was some. Over the summer, the parent took the child to see Dr. Freud, a private psychologist. By the way, and I am serious here, has anyone ever seen a child go to a private psychologist or psychiatrist for an evaluation who comes away without any diagnosis? No, I'm serious. I haven't. I've read the DSM, the Diagnostic and Statistical Manual of Mental Disorders, which private practitioners are accustomed to using. I've self-diagnosed as even having at least 5 syndromes, but we won't get into that right now. In this case, Dr. Freud diagnosed this child as having a nonverbal learning disability. The parent takes the independent evaluation and right before school starts, gives it to the school and said, I would like a special ed evaluation. The school does the evaluation, finds the child eligible, and develops an IEP. So why are we talking about a court case? The parent then initiated a lawsuit, initially a due process hearing that eventually got into court, stating that the school violated her rights by making a referral to the general ed team. She was not part of that team, and she argued that, among other things, her due process rights were violated because she was never apprised of her procedural due process rights under the IDEA until she asked for a special ed evaluation. The Court of Appeals said, so, not a quote. The Court of Appeals said the use of alternative programs, such as a general ed intervention process, is not inconsistent with the IDEA. It is sensible policy for local education agencies. And I know you have some co-ops. I may talk about districts, but when I talk about a local education agency, primarily it's a school district or a co-op. I may just use school district to mean the same thing, slip of the tongue. It's sensible policy for local education agencies to explore options in the regular ed environment before designating a child as a special ed student. The parent said, but this was being used as a roadblock to keep kids out of special ed. The court said, there is no evidence. First of all, are you legally required to tell me you've been referred to a general ed intervention team as a parent? No. But you'll hear me saying over and over again, doing just what is legal is not always the right thing to do. Keeping me, the parent, in the information loop, I think, is absolutely essential. In this case, the parent was made aware. As soon as the parent requested a special ed evaluation, the team considered her request and initiated the evaluation process. There is nothing to suggest in the evidence, the court said, that this was being used as a roadblock to keep kids out of special ed. By the way, in the last reauthorization of the IDEA, the Congress passed, amended the IDEA, and this was in 2004, that allows school districts, or LEAs, to keep up to 15% of their Part B dollars, special ed dollars, to be used for early intervention services. By the way, this is different than early intervening services. I mean, why do we make it so confusing? Those are Part C, birth through 3 services. These are monies that a LEA may use to promote interventions in the classroom for school-age children, not preschoolers, who have never been identified as special ed eligible. So the court even noted that the Congress made that determination, which is significant to show that the Congress saw that the general ed intervention process was sensible as part of the comprehensive scheme. Lastly, the parent argued that her procedural due process rights were violated because she was never given her due process rights when the school made the referral to the general ed intervention team. And by the way, we have to be careful when we say, well, you know, the teacher made the referral. Don't automatically assume that because the term referral was used, that it was a referral for special education. And by the way, when I'm the parent, and I said, I'd like to make a referral for my child, don't assume it's for special ed. Most parents are making a referral for what? Help for their kid. Finally, the hearing officer properly rejected, by the way, I've worked in all 50 states, the territories, Department of Defense schools. I've done training of hearing officers. Tomorrow will be 44 states. And as a trainer of hearing officers, I like it when a court says, the hearing officer properly did something. The hearing officer properly rejected the parent's argument that the procedural requirements of the IDEA apply to pre-referral processes. A student is not afforded the procedural safeguards which are required upon an initial referral for a special ed evaluation. The parents argued that this general intervention team, they had to make a decision eventually whether or not to refer the kid to for a special ed evaluation. They weren't part of it. So they argued, if, as the parents argue, any meeting regarding a child who is having difficulties triggers the procedural protections of the IDEA, then almost any action at all on the part of the school would constitute a referral. In essence, the parents argue that merely discussing the possibility of a referral for special ed becomes a referral, and that any time a child is not referred for special ed, the school has made an unlawful finding that the student does not qualify. Not only would such a system be counterproductive by discouraging teachers from communicating concerns about students, it would also prevent schools from trying alternative strategies for students who, while perhaps not meeting the definition of a child with disability, are in need of extra help. So this was an important case. Now again, doing just what is legal is not always the right thing to do. I would highly encourage a school to communicate to me about my child's referral to a general ed team, keep me in the information loop, and I know some schools even invite the parent to be part of that. But that's your decision. But the procedural rights don't apply until or unless either the school or the parent asks for a special ed evaluation. Questions, comments? Next case, it's called Compton versus Addison, Ninth Circuit. Ninth Circuit. This case was appealed to the United States Supreme Court earlier this year. The Supreme Court, well, they basically get to do whatever they want. They pick and choose which cases they hear. For 9 points, I was a social studies teacher. For 9 points, how many justices are on the United States Supreme Court? 8. Yeah, we have 9. See, I'm making it easy. The questions are going to be elevated in difficulty as the day goes on. If 4 of the justices say, yes, we think the issue is significant enough, we take the case, the legal term is granting a writ of certiorari, layperson's term that says, come on down. If the court rejects the case, that doesn't necessarily mean they agree with the lower court's ruling, but at this point they don't feel that it is significant enough to be elevated for the Supreme Court's attention. I was speaking last year in California to 750 people for 2 full days. By the way, I was telling my friend Roger, I did an internet webcast in California for 2 full days, the last reauthorization. there were 27,000 people online. And I was sitting there with the producer, the cameraman, and one other person taking questions, and I'm going to share it because you're my friends. They even put makeup on me. I was freaking out. But I was doing this 2-day thing in California, and during one of the breaks, one of the participants comes up to me and she goes, "I'm the special ed director from Compton." But I wasn't there when this happened. And she said, unfortunately, what the court said did occur. Here's what happened. Child never been found eligible for special education. She enters the 9th grade. Her teachers, they suggest that her work is incomprehensible. She's carrying a doll with her to classes all day. The teachers go to the counselor and said, "We are very concerned about this child." The counselor's response is, "Well, you know, some kids have an adjustment to 9th grade." The child failed all of her courses, first marking period. She started urinating on herself in class. They bring in a mental health counselor. The mental health counselor recommends an immediate special ed evaluation. That was not shared with the parent. At the end of the year, the child had failed all of her classes, no special ed evaluation, and she was promoted to the next grade. And we could talk about these cases. I keep thinking as a parent, I like to consider myself an advocate, as a teacher, what about this poor child? We could talk about these cases, but what about these kids? The next fall, the parent made an immediate request for a special ed evaluation. And one was done, and the child was clearly found eligible for special education. The parent then initiates a due process hearing. It gets up to the 9th Circuit in a 2-1 decision, because it's a panel at that point of 3 judges. See, I thought I had this one down pretty well. In a 2-1 decision, the court ultimately found that the parent's claims had merit. The dissent said the parent only could complain if the school refused to evaluate. And here, as soon as the parent asked for it, the school evaluated. I always thought, and by the way, when I said I got involved with 94-142, I was a child, a teacher at the time. Anybody remember 94-142? There's a few of us. I still have a T-shirt that says 94-142. I still have the original regulations from 1977, and I'm thinking I'm going to open up a special ed law museum, but I'm afraid nobody would come, you know? But I thought I thought this was kind of a given, that our responsibility as public school officials is that when we believe that this child may have a disability and may be in need of special ed, it is our affirmative obligation to initiate the special ed evaluation process. Our responsibility under child fine does not kick in only when the parent knocks at the door. The 9th Circuit agreed in a 2-1 decision. Hearing officers, I'm going to talk more about this case tomorrow with you because it gets into jurisdictional issues for hearing officers. But since this is a 9th Circuit case, I wanted to share it with you. Also, who's heard of RTI? Response to intervention. We are in a special ed law workshop. Surprise? Special ed law. I will tell you the term RTI is used in different contexts and different places. So if you hear, well, we used RTI with this child, my next question would be for that person, how are you using the term? The only place in the law where RTI is used is in, it gives, and by the way, this is in the Montana Code also, it gives a local education agency, a school district, the option when we suspect that a child may have a specific learning disability instead of relying on the severe discrepancy score. And I believe in Montana there's a 50% or more probability that a child has 2 standard deviations between ability and achievement. Instead of relying on that, we could adopt an alternative process called response to intervention. But response to intervention itself is not a comprehensive evaluation. It's an alternative to the severe discrepancy part of the LD definition. By the way, just because a kid has a severe discrepancy doesn't necessarily mean they're LD and eligible for special ed. The U.S. Department of Education, I think, has added to the confusion by this infamous memo that was sent to Frank and all of his colleagues around the country last year. Let me read part of the memo. And what I need to do is make the font bigger. It says, a state must adopt criteria for determining whether a child has a specific learning disabilities. The regulations allow a parent to request an evaluation at any time to determine if their child has a disability. The use of RTI strategies cannot be used to delay or deny the provision of a full and individual evaluation to a child suspected of having a disability. If the LEA agrees with the parent who refers their child for an evaluation, the LEA must begin the evaluation process. Although the IDA and its implementing regulations do not prescribe a specific time frame from referral for the evaluation to parental consent, it's been the department's long-standing policy that it should be done within a reasonable period of time. If the LEA agrees that an initial, if an LEA may conduct the initial evaluation within 60 days of receiving parental consent. The Office of Special Education has come to learn that in some cases, LEAs may be using response intervention strategies to delay or deny a timely evaluation for children suspected of having a disabilities. States and LEAs have an obligation to ensure that evaluation of children suspected of having a disability are not denied or delayed because of an implementation of an RTI strategy. Now listen to this. A multi-tiered instructional framework, often referred to as RTI, is a school-wide approach that addresses the needs of all students, including struggling learners and students with disabilities, and integrates assessments and interventions with a multi-level instructional and behavioral system to maximize student achievement and reduce problem behaviors. With the multi-tiered instructional framework, schools identify students at risk for poor learning outcomes, monitors student progress, provides evidence-based interventions, and adjusts the intensity and nature of those interventions depending on a student's responsiveness. What they just said is not RTI in the law. In other words, I was in one state, south of here. And the former state director, I was at the state conference a couple years ago, and he said, well, there's big RTI and little RTI. My first question, why isn't there a medium-sized RTI? What they were making the distinction, RTI as it's used in the law is very restrictive as an alternative way of identifying a child suspected of having a specific learning disability. RTI, as I just read from the federal memo, it's a school-wide approach that addresses the needs of all students. That's big RTI. In essence, what I think they are describing are what? As a school-wide approach to general ed interventions for kids with behavioral challenges, PBIS, if you've heard of that. They use the term RTI in this memo, which I think confuses things. I'm a legal cop, and I want to make sure that we're using the term properly. What they're saying is you can't delay an evaluation if my child is going through a general ed intervention process and I'm the parent and I'm knocking on your door and I want a special ed evaluation. You cannot legally say, well, Art, we have to wait until your child goes through the multi-tiered approach before we consider your request. So I wanted to make sure that you understand how RTI is being used to mean different things in different contexts. And this memo, I think, adds to the confusion by using RTI much more expansively than the law does. By the way, since I have your attention, it goes on to say, I asked for an evaluation. You don't see the need for an evaluation. If, however, the LEA does not suspect that a child has a disability and denies the request for an evaluation, the LEA must provide written notice of your refusal, and the written notice requirement talks about not only why you're denying, based on what data or evaluation did you make that determination, other considerations, other factors, other options, where a copy of my procedural safeguards if this is the initial referral. But it says you must provide prior written notice. How do you send prior written notice prior to denying? Dear Mom and Dad, rumor has it next week you're going to be asking for a special ed evaluation. We're telling you no now. The word prior makes no sense. And I have tried, and I know the people in the U.S. Department of Education, I have tried, and I'm going to still try until I evaporate from this earth, to have the word prior removed. I'm going to have more to talk about written notice when we get to IEP meetings, but you don't send, I'll just give you a hint, you don't send the parent prior written notice prior to the meeting telling me how my child's IEP will be changed. You too will be in special ed jail. Because that would be evidence of predetermination. The word prior is very confusing. We'll talk more about that in the context of IEPs. Now, I would dissuade you. I'm a parent, and I'm asking for a special ed evaluation because I just saw the Dr. Phil show yesterday on ADHD. And by the way, a couple years ago when ADHD, it was on the cover of Time magazine, the same week that it was on Oprah, schools around the country reported a number of additional inquiries, I mean, because of public awareness, understandably. You don't see the need. I think it would be incumbent upon you to sit down with me and having a conversation. Art, what leads you to believe that your child may have a disability? Well, I saw Dr. Phil. And Dr. Phil was talking about my child. Would it be fair to say most parents don't even know about the general ed intervention options in your school, unless maybe an older sibling has gone through that? Talk to me about those options. I still want a special ed evaluation. And by the way, this is one of the cases where this person's cousin was taking introduction to school psychology. And she's diagnosed as part of her studies her nephew. And the parent wanted a special ed evaluation. You have two options. One is to do it. The other is, and people, it's not tough, not to. In either case, you have to send me written notice of what you're proposing or refusing along with my procedural safeguards. If a parent is really insistent on a special ed evaluation, unless you have real good reason, I would say just do it. How can you prove that my child is not disabled and doesn't need special ed unless you have evaluation or assessment data to support your conclusion? Is it really worth going to legal war over at this point of the game? I suggest not, and I think you have to look at the pragmatics. We have a question or comment. Wait, we need this for our friends in cyberspace. Thank you.
Hello, cyberspace. It's on. In Montana, we have great conversations with our parents rather than just automatically. Can you hear me over there?
Yeah, this is just for the people in cyberspace. That
automatically, rather than just getting parental permission to evaluate, I would think that having the parent become a part of a conversation to take a look at what interventions are in place, what are we doing responsively to meet that student's need, and develop a relationship with the parent may be an intermediate step.
And if I heard your comment correctly, I think it's in concert with exactly what I suggested. To bring the parent in, have a discussion with the parent. What are your concerns? Here is what we're also, concerned about your child. Here's what we are proposing as our efforts to help your child, and to keep that partnership. So if I heard your comment correctly, I think what you just emphasized or underscored the point I was attempting to make. Anything else at that point? One last case, and we're not going to go through all of these in intimate detail, but it's called DG versus Flower Bluff. And this child was in 9th grade. No history of academic or behavioral issues. By the way, I've been in this field a long time. Someday I'm going to write a short story book. Last school year, I get a call. The school district initiated an evaluation because they felt that this child was suspected of having a learning disability, and the child was graduating from high school in 3 weeks. The school initiated the evaluation 3 weeks before high school graduation. People. In this case, we have a 9th grader who had no history of academic or behavioral issues. And now what I know about this case is what the court said. And we always know that hearing officers in courts, always with 100% accuracy, get all the relevant facts. In this case, in 9th grade, the student started having some truancy issues, behavioral issues. Stole some money from the teacher's desk. Lesson learned, don't keep money in your desk or lock it. Had been sent then to an alternative program that the school ran for kids who had some serious behavioral issues. Right after that happened, how old was the student? What grade? 9th grade. Mom gave the school a diagnosis that she received from Dr. Freud, a private psychologist, indicating that her child had an attention deficit hyperactive disorder. However, that diagnosis occurred when the child was in 5th grade. So in other words, the parent never shared that information for 4 years. For the parents in the audience, when I talk about relationships, it's a two-way street. Schools, you better share with me relevant information. Parents, if you want the school to help your child, you need to do the same also. In this case, Mom asked about this thing called 504. The school initiated a 504 process seeking input from the parent. The parent shared that the student had been, that the parents had gotten divorced a couple years back. The student was estranged from his dad, which caused a real loss of self-esteem in him. He was angry because of his parents' divorce. He argued all the time. He wouldn't do his homework. He lied to his parent. He used profanity. And he was using the computer for improper purposes. Sounds like adolescence. No, I'm only kidding. Mom said, I have seen an improvement since he has been put on medication, however. However, homework makes him tired. I'm asking that homework be waived. My oldest son would have self-referred if he knew that would. A student assistance team, a general ed intervention team was convened, and they found that the child did qualify for a 504 plan, so they 504'd him. Did you ever hear 504 as a verb? Oh, we 504'd him like 3 weeks ago. So they 504'd him and provided accommodations. The student returned from the alternative program to the main campus. However, there was another major fight in school. The student was returned to the alternative program. The 504 committee met, found no manifestation between his behavior in school and his 504 disability, so they kept him in the alternative program. The parent then asked for a special ed evaluation and simultaneously asked for a due process hearing. The school, as part of the pre-hearing process, said, we don't see the need, but we'll do the IDEA evaluation. But parent, we need your consent. Here's a consent form. The parent waited from August till November to provide the consent. Ultimately, the evaluation was conducted. The child was found not to be IEP eligible. Whoops. Not to be IEP eligible. The parent then added to the due process hearing. The hearing officer affirmed the fact that the child was not IEP eligible. Ultimately, it gets to the Court of Appeals. The Court of Appeals says no court has ever addressed whether a school district could be liable for a child fine violation if the student is ultimately found not eligible for special education. Here, there was an argument. The parent argued that the school did not act in a timely manner in getting the evaluation done. The school argued we couldn't do the evaluation without the parental consent, which was not provided in a timely fashion. Now, lesson learned from my hearing officer friends. The hearing officer found that the kid was not eligible, so affirmed that, never addressed the timeliness of the evaluation in their decision. So that became a problem. In this case, the court held that even if the evaluation was not timely, even if the school district had not timely evaluated the student, the IDEA does not penalize a school district for not timely evaluating students who ultimately are found not to need special education. So, no violation. Knowing some of us who are attorneys, knowing what it takes and the time frame it takes, and both the economic cost and the emotional cost to families and to school staff of going to due process, then going to federal district court, and then going to the Court of Appeals. I bet you this 9th grader was probably in postdoctoral training by the time the 5th Circuit spoke. So you've got to look at the pragmatics. MJC, a case that I wanted to talk about on page 4, paragraph E. And I want to do so by first noting that under the other health impaired category under the Montana Code, you need a doctor's diagnosis as one component of that comprehensive evaluation. That's not true under federal law, but about half the states have, under OHI in particular, a doctor's diagnosis. In this case, MJC, this used to be the law according to Art. Now I have some cases to back me up. In this case, the school said, in essence, Mom, we don't know where Dad was, but Mom, get the medical diagnosis from your child's physician and we'll pick it up from there. Apparently, the mom was not timely in doing so. Bottom line, lesson learned. The law says that you cannot require the parent to get one of the required evaluations to determine eligibility or to determine the needs of the child. So in Montana, as about half the states, since you need you are required to have a medical diagnosis under OHI, you may feel a medical evaluation is required in other situations, either for eligibility or service needs. It is up to you, the school, to see that medical evaluation is provided at no cost to me. Now, I'm bringing this up because this case cited a case called NB versus Hellgate, which is an older case. It's not in your outline. It's a case probably 5 years old, 6 years old, from the Ninth Circuit, where the parents moved from New Jersey to Montana. Their child had been found eligible in New Jersey under the developmental delay category, but the child's pediatrician from New Jersey wrote a letter that they suspect that this child showed symptoms of autism. So the school in Montana, and I won't get through all the facts, said, Mom and Dad, we have a clinic here. I think it's called a Child Developmental Clinic. Child Development Center. Here's their name, here's their phone number. They will provide an evaluation to determine whether your child is autistic at no cost to you. Just let us know, and we'll pick up the pieces. Ultimately, the Ninth Circuit held, and this is a very famous case, that a school cannot, quote, abdicate its affirmative responsibilities under the IDEA by simply making a referral to the parent and asking the parent to follow up. Now, in the NB case, it was at no cost to the parent. The MJC case cited the NB case for the proposition, not only must you ensure that all evaluations are done at no cost, you cannot require the parent to get a medical evaluation if one is deemed necessary, either for eligibility purposes or service determination purposes. And since your code, administrative code under OHI, other health impaired, requires a medical diagnosis, by the way, a medical diagnosis alone doesn't answer the question, but it is one required component of. Now, in Art's opinion, because I can't give you advice. So here's the team. And the team says, Art, we will provide a medical evaluation for your child because we need a medical component. And I said, well, thanks, but I'd rather take my child to Dr. Spock, his pediatrician. And if I decide, you've offered in writing, that's part of the written offer of the written notice of the evaluation, to do the medical, and I choose to go to the doctor, my child's regular doctor on my own, that's distinct from this case. This case, a parent cannot be required. So, I talked about this case at the Pacific Northwest Conference a couple days ago in Seattle, and there was about 500 people there. You should have saw the faces that I saw. I saw some faces here. I hope this was not new news to you. I hope it's an affirmation. But be prepared, especially under OHI, you don't have the option of just eliminating a medical diagnosis because your code requires it as one component. By the way, I would also want to make clear to the parent from the very get-go that a medical diagnosis or a psychological classification under any category does not in and of itself qualify a student for IDEA services or 504 services. And can you just, now this is for the audience, so if you could just speak up. So.
my question just has to do with where I'm at currently isn't a huge rural area, but I know in Montana we have a lot of rural areas. And, you know, where I'm originally from, you could be looking at a couple, 3 hours to see a drive to see a psychologist and stuff. And my question there becomes, as a school, what are we, you know, to not say it betterly, but what are we on the hook for? Do we pay travel expenses? If it's an overnight thing, do we have to put them in a motel room? Are we supposed to provide transportation? And I know that's kind of getting into a very big scenario there, but I just am wondering, if we do send a kid to get that diagnosis, what exactly do we not have to pay for, but what should we pay for?
All of the above. Next. But let me just say this. I think there's some alternatives, and I think there's two alternatives. Number one, I know in my home state, Vermont, and I live part-time in Hawaii, Hawaii has the third most per capita hearing decisions of any state. And I thought, what? Hawaii? You have a problem? Take off your shoes, you know, wiggle your toes in the sand, get a Mai Tai, and let's talk it through. But, I mean, it doesn't always work that way. But I was in Alaska last week, and I do a lot of work in Alaska. You may be rural. You're not remote. I have been in a village that's 400 miles from the nearest road. So you're kind of, you know, looking good. However, a lot of the services, and sometimes, I think there's two options. One would be a long-term solution, and that is the next time your state regulations come up. I know in our state, this became a very heated issue, but we changed our state regulations to say, under OHI, the team shall secure the opinion of a psychologist and/or physician as the team determines. In other words, for example, ADHD is under the other health impaired category. If I had suspected that my child was ADHD, I know some psychologists who I think would have given a lot more involved and in-depth assessment that would be useful to the team than what I've seen oftentimes is a 15-minute office visit with the physician who writes on the prescription pad that Bubba has ADHD. So that's the long-term solution. But in the short term, I will tell you one of the things that they do. First of all, ADHD, ADD, now there's other health impairments besides the two, but ADD, ADHD is probably the most common classification under OHI. You don't need to take a blood test. In other words, I have seen those evaluations occur over Skype with the physician. Now, that may not always be possible depending on what the child's medical condition is. But that's another option, especially for ADD, ADHD. Because how does a person diagnose ADD or ADHD? It's input from observational information from a variety of sources, including the parent, teachers, other service providers. So that's, if you feel that this child does need a medical evaluation, that medical evaluation does need to be an in-person, that does have to be provided at no cost to the parent. And I will tell you that by the way, special ed administrators, how many of you get calls from your staff saying, "It is just a wonderful day. Can you come over?" I don't get the calls. I don't get the calls from your colleagues saying, "Art, everything is going well. We thought we'd just call and let you know." But I believe you have 16,000 plus kids on IEPs in Montana. Is that correct? The number of cases that get kind of off the road are teeny, 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 teeny. That they can consume you, but they're teeny, teeny, teeny. I get the teeny, teeny, teeny case questions. If you send a child, you will have to provide mileage and reimbursement and so forth. You should, most of your districts probably have expense policies that put some limits. You want to consider making sure that those expense policies are made privy to the parent. Example, in Vermont, we had a child who did need a special evaluation by a very specialized medical person that was only available in Boston. And the school paid for it. The parents got a suite at the Parker House, which is a very nice hotel. The cost of the hotel was twice as much as the evaluation. Now, most parents are, I mean, by the way, you know, I've seen parents outside of Montana push the envelope. I've seen school administrators and staff outside of Montana push the envelope. Sometimes bad facts make bad law, and it's unfair to paint parents with a brush. It's unfair to paint schools with a brush. Sometimes people push the envelope. Suite was $1,200 a night. They said, you didn't give us any limits. And by the way, they brought their 5 children with them and had a couple nights. I mean, I guess they had a nice time. But what I'm saying, the answer is it would have to be provided at no cost if it does entail travel. But there's other avenues such as using technology if that's an alternative. Anything else before we move on? And by the way, just a little plug here for Montana. You had how many hearings last year? 0?
1.
Oh, you had, okay. You also have your Early Assistance Resolution Program, or Early Resolution Assistance Program. You have your mediation program. In other words, I'd like to believe that the reason we don't see a whole lot of legal action from Montana is that schools and families are working together, working through our differences, but working through them respectfully so we could stay on the road together. Instead of, I've seen other people, I'll never forget this. I was in another state, we'll call it the state of confusion. And this administrator came up to me and says, Art, thank you for your presentation, but all this parent participation crap. I have seen that district now in 2 court cases. I'm not surprised. You approach it with that kind of attitude, you get what you deserve. Bottom of page 4, top of page 5. Called KS. Oh, this is from the 9th Circuit. Here was a child, and by the way, what are the purposes of an evaluation? Eligibility, and then service determination needs. This case was clearly, this child, the KS versus Fremont case, this child was clearly eligible for special education. There was a question, however, this child was autistic and was intellectually disabled. There was a question of whether the child was making adequate progress, was receiving educational benefit under their IEP. A 40-page hearing decision. The parent alleged that the IEP was not allowing the child to make meaningful educational progress based on their intellectual abilities. Neither the school district or the independent evaluator hired by the parent could assign with any comfort level an IQ score to the student because of the student's significant disabilities. Therefore, as the parent's argument goes, we cannot assess whether the child has made educational progress. Here's what the 9th Circuit says. KS contains an IQ score is a legal prerequisite to a determination that a student is intellectually impaired. Thus, KS argues because neither the school district nor her private testers were able to obtain an IQ score for her, the administrative law judge, i.e. hearing officer's, determination that the student was cognitively impaired could not make greater progress toward her IEP goals than she did was legal error. This contention is without legal basis, according to the court. The determination that the student had a cognitive disability was valid based on expert testimony, her results on alternative cognitive tests, her IEPs, and her progress reports from school. So, first of all, and I talk about this case because not only it's from the Ninth Circuit, but secondly, the law has taught us we never rely on any determination, whether the child is eligible, whether the child has made progress or not, based on one piece of data, such as a score, an IQ score, a test score, etc. The law requires us to collect, to be honest, I get these questions still. Well, we're testing this child for special ed. It's not a pass-fail test. I mean, I don't know if you pass, you get in, or you fail, get in. But I mean, it's not a test. It's an evaluation that consists of multiple elements: parent input, teacher and other service provider input, observational, classroom-based data, and also could mean more standardized test scores as one component also, a medical evaluation or diagnosis as we discussed. But you never rely on one piece of data to make a decision. The Ninth Circuit held that there was consensus by the evaluators that we could not assign an IQ score with any reliability to this student. However, that did not prevent the ALJ, or hearing officer, administrative law judge is what ALJ stands for in some states, from determining that this child had an intellectual disability and therefore the progress she made was consistent with her ability. Who's having fun? Let me ask you here, because I want to really focus on issues that are most relevant to you. And I'm just going to guess that several of you, this would not be that relevant. How many of you have private schools within your school district? Keep your hands up. How many of you have kids who are being homeschooled in your district? And by the way, homeschool is not where the IEP team places a child at home, but where I, the parent, make that determination. Because I think this really has the same analysis. Here was a kid who had been in a public school, had been identified as special ed eligible. The parent made the decision to remove him from the public school and place him in a local private school. Didn't ask the school to pay for it. There was nothing. He was in the private school for a couple years. The parent then says, you know, well, first of all, it's an expense to a family. Maybe we should consider placing our kid back in the public school. So they asked the public school to update their child's evaluation and to prepare an IEP. The school said, we will be happy to do so if you enroll your child back in our school. The court held, I think correctly so, consistent with IDEA policy, that is illegal. That the offer of, that the need to do, in this case it was a reevaluation. Why? Because the child had previously been found eligible some years back. A reevaluation and making an offer of FAPE is not contingent on my enrolling my child back in the public school. You are obligated to consider evaluating or reevaluating the child, and if my child is eligible, developing an IEP. However, the implementation of that IEP can be contingent on my enrolling my child. Here's what I like what the court had to say. So let me just quote this part. If the court were top to the school's position, privately enrolled children with disabilities, and by the way, Art would say this is not just for kids who are enrolled by their parents in private schools, but kids who have been homeschooled. If privately enrolled children with disabilities would not have available to them a FAPE, parents would have to enroll their child in the public school with no information about the type of program that the school may offer, where the child would be placed, or even if the IEP would constitute a FAPE. The child potentially would lose risk losing their place at the private school without guaranteeing that the district would provide an appropriate education. Surely, Congress did not intend to turn special ed into a game of poker. I thought with the casino here this was... Surely, Congress did not intend to turn special education into a game of poker, where a school district does not have to show its cards until the parents have taken the gamble of enrolling their child, and the child bears the risk of losing an appropriate education. Thus, without the remedy that the parents are seeking, a child's right to FAPE would be less than complete. Now here, and I just want to restate this. My kid is in a private school in your district, or I'm homeschooling my child, and I'm a resident of your district, and I want an evaluation. I think you have an obligation to consider that evaluation. If my child is eligible, develop an IEP. By the way, making it clear to me from the very beginning that this IEP is contingent or conditioned on what? Enrolling my kid back in the public school. The offer of FAPE is not dependent on enrollment. The provision of FAPE is contingent on the offer of enrollment. You see or hear the distinction? There was Mary, a question way in the back here, or a comment. And again, this microphone is just for our folks in cyberspace. So I would ask that if you have a question or comment, use your lunchroom or playground voice so everybody in the room could hear.
Okay, my question is just in regards to this case. If you have a student or a family who has contacted you who currently lives in the district, but the child is maybe living with a relative out of state, and they're wanting to have the child back into the district with the same situation contingent upon re-enrollment, how do you go about?
I actually looked up the legal residency statute last night in Montana. Mm-hmm. And the legal residency statute, and correct me if I'm wrong, is, as most states for minors, it's where his or her parents reside. Mm-hmm. So assuming the mom and dad are residing in this Correct. District, but at this point the child is living with grandma in Wyoming. Yes. But I believe that child still has residency for education purposes in Montana. You would not have to go to Wyoming to evaluate the student. You would have to make that evaluation available where the residency is. And you would not have, if the kid is found eligible, you would not have to provide services in Wyoming. Now that would be my analysis. Because residency, and by the way, the Montana statute on residency is not special ed. It applies to all children. I thought I might get that question, so last night I looked it up. Okay. Moving on. The next case is DP. I'm going to go through this. It's kind of sad. Here was a child with autism and a speech and language impairment. The child had been on an IEP. The parents pulled him out of school. Tragedies occurred. In December of the year, the family house burnt down. 2 days later, Dad died. The parent said that the school had an obligation at that point, when they became aware of the tragedies, to reevaluate the kid and to pay and to have an IEP that called for the kid's maintenance in the private school to add some stability to the child's life. The Third Circuit Court of Appeals said no. The parent never requested an evaluation. The fact that the school was informed of it, because it was a relatively small community and everybody was informed of the tragedy, imposed no affirmative responsibility on the school. And again, if the parent said, in light of everything, we're asking that you reevaluate and prepare an IEP, you would have to do so. The IEP implementation would be contingent. The parent never even made that request. Notice and consent. On the very bottom of page 5, top of page 6. This was a reevaluation. and I'm the parent, and you have to notify me in writing and get my written permission. So consent is defined as voluntary written permission anytime you're proposing to evaluate my child for special ed or reevaluate my child for special ed if it's going to be more than a review of existing information. For a reevaluation, if you have documentation of reasonable attempts to get my consent and I have not responded, the law allows you to go forth with a reevaluation without consent, but I would do so carefully. In this case, Mom and Dad were asked to give consent for a reevaluation, and they did, with a little asterisk saying, subject to the conditions attached. And there were I believe seven conditions, such as the evaluation will be done by Dr. Phil. We will be able to meet with well, they didn't name Dr. Phil, but a specific person. We will be able to meet with Dr. Phil prior to the evaluation to find out exactly all the instruments that will be used during the administration of the reevaluation. We will be informed of the date of the administration so that we can be physically present to observe the administration of the assessments. We will then be able to speak with Dr. Phil prior to his issuance of his report to the school on the reevaluation. The school said, we don't think so. Ultimately, the Court of Appeals, and this is the 11th Circuit, said by imposing all of those conditions on the reevaluation, that was a de facto refusal to consent. Because the school has a right to conduct an evaluation or reevaluation by qualified individuals of their own choice under standard conditions. Now, help me here. Even though it may not be malicious, I'm the parent and I'm observing my child being assessed, and maybe they're asked a question. I go, tell the doctor, you know that, you know that. In other words, obviously, or just my presence could have an impact on my child. The court held that by imposing all those conditions, it was a de facto refusal to consent. Independent educational evaluations. At any time first of all, I can get an independent evaluation at any point at my own expense. Oh.
On what you just said, does that work the other way? That is to say, can the school do the same thing? Impose all sorts of conditions?
Impose all sorts of on their own evaluator?
Yeah. Well, as the parents did, but it comes from the school.
I think, depending on all those. First of all, I find in smaller states like Vermont, and you help me here in Montana, especially some of our smaller districts, we don't rely necessarily on our school employees to conduct all the evaluations, but we may have to contract with some of the private practitioners to conduct some of those evaluations. Is that true, especially in some of the smaller districts here? I'm glad you brought that up, because 2 points, lesson learned. If you contract with a private practitioner as a school district to conduct a school's evaluation, that person is really acting as an agent of the school. So you want to make sure you have a contract with that person so she or he knows, number one, that there's a certain time frame that they're working under. Two, that all the data that they accumulate as part of that assessment that leads up to their report will be deemed education records and not sole possession, such as a test protocol, which means it's not theirs, it's the school's records. You want to make sure that all those issues, so in other words, it's a different ballgame as a private, if they're acting solely as a private practitioner as opposed to a contracted agent of the school. They are then subject to all of those requirements. Now, so let's assume it's a school psychologist or a contracted person that the school's going to require. I think that the school psychologist has a right to demonstrate standard practices in the administration of those assessments. and that if the school psychologist feels that the presence of others is going to impact the reliability of that data, that I think that they are in a position to object. Which, by the way, then the school could say, well, thanks, Art, but then we're going to contract with someone else. I mean, but different with an employee. But I want the same standards to apply.
Now, conversely, if the school decides that they want to have other people present, the teacher, for example, can the parents object to that?
Sure, they could object to it. They could object because you have a green vest on.
My wife gave me that.
So, can they object? Yes. Is there a basis for their objection? No. I was answering your question. Can they object? I could object because I don't like, the color of your socks. But in other words, there would be the parent does not have a legal right to prohibit the school personnel from being there if that's a choice. But on the other hand, then I would say, then I want to be there too. No, you can't. Well, if the school folks aren't going to in other words, being even-handed.
In western Montana, we have a number of treatment centers where students' parents spend lots of money to place their children, and the majority of those students are high school students and come from out of state. So I know my responsibility for child find. I know that I have to follow the administrative rules of Montana. In working with the parent's resident school district, however, sometimes their state's administrative rules get a little convoluted with Montana's. The other question I have for you is, so my question is, what's best practices for me to follow? And the other is that sometimes these students may come to that treatment center with an IEP, but the treatment center will never let the public school know that that IEP is there, and sometimes the school district has sent the student to that treatment center, but what's my responsibility for offering a service plan?
Let's see, true, false, all of the above.
Thank you.
I mean, you had like 17 questions embedded in that hypothetical. Just a couple general principles. First of all, if I am, and by the way, there's a case out of the Ninth Circuit called RB, where the parent from California placed their child at the Intermountain School in Montana. The issue then became the responsibility of the California school district, not the Montana district. Or a state agency from another state places a child there. Different. An IEP team from Montana or elsewhere places a child there. I see the placing agency ultimately responsible. Now, I do know, and I've read your code, that in a residential treatment facility or psychiatric hospital, that institution is supposed to develop and provide FAPE. If they are unable or unwilling, I think your code says, it's the district where the facility is located. In Art's opinion, I don't believe you are responsible for out-of-state students.
Even evaluating them?
Evaluating, let me ask you, in a private treatment facility or psychiatric hospital, are they considered a private elementary or secondary school under your state law? By the way, people can't hear you. She is shaking her head, yes. So let's take it out of the facility for a second. I reside here. My child is in a private elementary, nonprofit elementary or secondary school that's physically located here. This district has child fine responsibilities and ultimately would have to offer a service plan. This district of legal residence is the district that is responsible for offering and providing FAPE. So, child fine. So, a child from out of state is placed in your facility. And this came up in a case out of Massachusetts and Connecticut, where Massachusetts said, we will evaluate all Massachusetts residents, but we're not going to evaluate out-of-staters placed in Massachusetts. And the feds, in private schools in Massachusetts, yes, you will. No, you won't. The Fed said, yes, you will. Massachusetts said, no, you won't. The Fed said, we hold the check. Massachusetts reflected on that. Ultimately, the federal regulations were changed to say that you would have to evaluate even out-of-state students who are attending private, non-profit elementary or secondary schools that are located within the geographic bounds of your district. In Art's opinion, you apply Montana standards. You don't apply Alaska standards, California standards, or what have you. And by the way, I have spoken with the Office of Special Ed Programs, OSEP, i.e. the feds. I've spoken with them about that, and they have concurred. But I have not seen a case on which state standards you apply. You apply the standards that applied in your jurisdiction.
I heard you say something important about non-profit.
Non-profit.
How do I know that these treatment centers are non-profit?
I will have to defer. I know that in some states, and Frank or Mary, I don't know if you are able, in some states, the state maintains a list of private elementary and secondary schools to determine if they're profit or non-profit. By the way, hold that thought, and here's why I am saying that. And look at the reauthorization better occur quick. Look at my regs are falling apart. This is a publication from the government printing office. That's a comprehensive, it's all the comments, all the regulations. This is great. There were so many requests for this that the government printing office said we're stopping printing it. Discuss. So, but here's why I am saying that. And by the way, there is a Ninth Circuit case out of Arizona on this. The definition of elementary school, a reading from the federal IDEA regulations. 300.13. Elementary school means a non-profit institutional day or residential school, blah, 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 blah. Secondary school is under 300.36. Secondary school means a non-profit institutional day, blah, 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 blah. That's why it's non-profit. That's why the analysis has been non-profit. The U.S. Department of Education has also issued guidance to that effect. So let's assume I'm residing here, but I have placed my child in a for-profit elementary or secondary school. The District of Legal Residence is responsible for child fine. So there. And I don't know, Mary or Frank, do you know if the state maintains a list of profit or non-profit private schools?
I don't think. Frank said that we actually just keep the list of accredited schools. DPHHS would have the profit or non-profit list of facilities that are schools.
And then, I mean, absent a state list, you would have to make an inquiry. Yeah. Are they organized as a 501c3 organization under the IRS code? I'm not going to get into IRS law. Let me do this so that we could just finish up before we take our mid-morning break. Independent evaluations. If I disagree with your evaluation, I have a right to get an independent evaluation at your expense. You must pay for the independent evaluation or initiate a due process hearing without undue delay. The team must consider the independent evaluation. The independent evaluation must meet the same criteria as the school uses for its evaluation. And I am entitled to one independent evaluation at public expense for each school district evaluation I disagree with. Page 6. We have two cases here, neither of which are Ninth Circuit, but they're in disagreement with one another. Must I first inform you as a school that I'm going to be seeking an independent evaluation at your expense? One court said yes, the other court said no. Now, this is assuming the parents could take the financial risk of getting the independent evaluation and not having any level of assurance that they're going to be reimbursed. And not all of our families could take that financial risk. Secondly, well, before I get to JP, so let's assume I get an independent evaluation. And I go to Dr. Freud, and she evaluates my child, and I give you Dr. Freud's evaluation report. What must you, the school, do? Consider it. By the way, it could be on eligibility issues, but it could be, it's clearly my kid is eligible, so it could be on service or placement needs. How do you consider it? Who considers it? The team, not just the school psychologist. Now, there's an old case that I just talked about in Seattle, but this is supposed to be in the last 2 years, so this is a bonus. It's called Seattle versus BS, where this child was clearly eligible for special education. I think this case came out of the Ninth Circuit in 1995. This child was clearly eligible. The debate was, what level of services and placement does the child need? So the child was taken to a private psychologist. The psychologist issues a report that the child has a conduct disorder, attachment disorder, etc. Where do those terms come from? DSM, the Diagnostic and Statistical Manual of Mental Disorders, which is a classification system established by the American Psychiatric Association. And private practitioners customarily use DSM codes because, among other things, they use them for insurance billing. By the way, DSM-5 is coming out here shortly. Big controversy on the issue of autism and Asperger's. So I wait with bated breath to see what DSM-5 is going to say. What relevance do the DSM classifications have on a child's special ed needs? By the way, let me just share with you, if you haven't read DSM, the DSM codes are not always closely aligned with the categories of disability under the IDEA. In the BS case, no one on the team was able to answer that question of what relevance do all these DSM codes have on the child's special education needs. The court held since no one on the team had any knowledge to help their other team members understand the import or lack of import of those DSM diagnoses, the team did not give it due consideration. Secondly, the Ninth Circuit said, when the independent evaluation paints a real different picture than the school's evaluation, it's incumbent upon the team to probe further to find out, why are we getting such different pictures of this child? And sometimes schools need to acknowledge, we overlooked all of that. That's the whole reason, in essence, of getting a second opinion. At times, you need to probe further to find out, how did our school come up with its conclusions based on what evaluation assessments, and how did the independent evaluator do so? And have to ultimately make a credibility determination. You must pay for it unless you take me to a hearing. And it doesn't make sense to go to a hearing. I see these issues go to a hearing when Dr. Freud said this child needs 40 hours of home-based services or needs to be placed in the following residential placement. And that's really the issue. One of the sub-issues is the independent evaluation. This case I'm about to talk about, I could scream, but I won't because I'm polite. I was just in Anchorage last week. JP versus Anchorage. Here was a child who, at the end of first grade, the parent went to the teacher and said, you know, our child had a bumpy year, as you know. We talked to some friends. We would like our child evaluated for special ed. The teacher says, well, summer's coming up, so we can't do the evaluation. You'll have to wait till the fall. That's not. In August, like a week before school started, the parents wrote a letter to the principal stating, we want a special education evaluation to determine whether our child is learning disabled, it has an attention deficit hyperactive disorder or other disorder, blah, 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 blah. The child was starting second grade. The second grade teacher and principal met with the parents. The testimony was, we weren't clear what the letter was asking for. The court said, it was unambiguous. I mean, they used the word, we want a special ed evaluation for. So the court said, you know, we don't give any credence to the testimony, you didn't know what they wanted. That was in August. 45 days later, and by the way, at the time there was a 45-day evaluation period in Alaska. What's the time for conducting an evaluation in Montana? 60 days. What's the time on acting on a referral? I asked for a special ed evaluation today. How many days do you have to respond to my referral, my request? I heard it. There is no specific set time under federal or state law. Within a reasonable period of time. Now, from my parent perspective, I'm saying, what are you doing over the lunch hour? There is no time frame. Some states have it, most states don't. Now, everyone's going to write this down because Art said it. If you write it down, put it in pencil. I have recommended that I would like to see no later than 2 weeks after the request is made, a response from the school. And I think the longer it takes, the greater responsibility you will have to articulate why the response was delayed in responding to my request. And I picked 10 days because it's a nice round number. And by the way, this applies during the summer. It applies during breaks. Now, 2 weeks. And I have seen situations where on the afternoon of holiday break, the parent has requested a referral. And how long are your schools out for Christmas, New Year's break? I mean, there are going to be, at times, extenuating circumstances. So I said, as a general rule. In this case, the parent got an independent evaluation in November. The school still had not started its evaluation. The school used part of the parent's independent evaluation as its evaluation, and ultimately at the end of January found the kid ineligible for special education. So therefore refused to reimburse the parents for the independent evaluation. It goes to a due process hearing. The hearing officer held that the parents were entitled. By the way, the parents got some private tutoring also. It gets up to the Alaska Supreme Court. And the court, I believe, correctly held that the right to get reimbursed for an independent evaluation is not ultimately dependent on whether the child is found eligible for special education. Now, hearsay. The cost of the independent evaluation was about $1,100. I understand negotiations for attorney's fees are approaching $300,000. Would someone during break like to join me for a primal scream outside? that's why you really need to look at the pragmatics of the situation. And I know it's time for a break, and let me just end on this issue. Bottom of page 6, top of page 7, CW versus Capistrano. They waited 41 days to ask for a hearing to show that its evaluation was appropriate. The court said, based on the facts there, that was not undue delay, because in that case, the parent did not specify why they disagreed, which necessitated meetings with the staff and the parent to review all the assessments to try to find out what part the parent disagreed with. The court held 41 days was not undue delay based on the facts of that case. Now it's time, I believe we have a 15-minute break scheduled. One last time I'm going to ask you, who's having fun? Go.